Good afternoon. My name is Renee Castillo de la Cruz, and I'm a staff attorney at the Texas Children's Commission. I would like to welcome you to today's webinar focused on trial skills for child welfare cases, entitled Laying Your Evidentiary Foundation. This presentation is provided by Michele Surratt, Managing Attorney for DFPS Region 9, and Tiffany Reedy, Managing Counsel for the Child Protection Services and Disability and Elder Law Divisions at the Harris County Attorney's Office. A PDF copy of the PowerPoint for today's presentation is currently available for download on the Commission's on-demand webpage. Additionally, the Q&A feature is available for this webinar, and questions will be addressed at the end of the presentation if time allows. I will now turn it over to our co-presenters, Michele Surratt and Tiffany Reedy, to begin their presentation. Thank you.
Thank you, Renee. Tiffany and I are going to talk to you today about laying some foundations for some exhibits that we commonly use. This is probably not the end all to be all to every exhibit that you may use in a CPS case, but we're going to try to hit some of the high points. So I'm going to start with certified copies. Certified copies, basically this is a public record or report. You want to look at your Texas Rules of Evidence 901A7, and then also you want to look at 902.4. This is evidence that a writing is from a public office where items of that particular nature are kept. They are self-authenticating, so you don't have to necessarily have a sponsoring witness or a business record affidavit or anything like that. You're usually just going to say, Judge, I move to admit Petitioner's Exhibit 1 or Respondent's Exhibit 1. This is a certified copy of judgment and sentence regarding respondent father. So that's pretty much what that certified copy is. So some examples might be, like I said, a judgment and sentence from a criminal case of one of the parents, pen packets if they're currently in prison, if one of the parents is in prison. You can also get your court orders, such as your adversary order, your status order, family plans of service, anything like that, indictments, court of continuing jurisdiction, things of that nature will be certified copies because they come from a place that keeps those as they're regularly kept in that nature. And so I'm going to pass it over to Tiffany. She's going to talk about photographs.
Thanks, Michele. I appreciate that. So in most of our CPS cases, in these child welfare cases, we often have photographs. We have photographs of children. We have photographs of, injuries. And so understanding how to lay the foundation to get them in is extremely important. So hopefully none of you are highly offended. If you already know how to do this, this is just a refresher. But for those of you who have that angst, if you're a brand new lawyer, this is your first time trying to admit evidence, having some of the tips that we're going to give you in this training is going to be extremely helpful, right? So in order for us to be even talking about photographs, they got to be relevant, right? So when we talk about the evidence that we want to use in connection with proving our cases, whether you are the prosecutor, whether you are the child's ad litem, whether you are the parent's attorney, your photos have to be relevant, right? The witness that you're going to prove up your photograph through has to be familiar with the scene or the item in the photograph, right? And they also have to be familiar with when the photograph was taken. That doesn't mean that they have to be there, though, right? So, and your witness also has to be able to testify that the photograph is fair and accurate, right? As a depiction of the scene or the item that is depicted in the picture, that it actually appears to be the thing that you're going to be, trying to offer into evidence, and that it appears on that photograph on the date it was taken. So focusing more on our younger practitioners, right? And for people who've never done child welfare, and for some people who just decided that they're going to try this as an area of law, if they want to switch over, and folks who've never really entered evidence, you can't just, decide that you're going to, offer the photograph without asking some questions first, right? So you want to ask some lead up questions to proving or laying the foundation for this photograph. So testimony from a witness prior to requesting admission of the photograph is crucial. Tailor the questions to the witness, keeping in mind the photograph you're trying to admit. An admission of the photograph does not have to be through the person who actually took the photograph. Okay, so an example, entering photographs from a doctor. In most of our cases, we're going to have a lot of photographs, especially if it's a serious injury case. You may have photographs that depict bruising, that depict injuries. You may also have photographs not from a doctor that depict dirty houses or, clean houses. So if we're using the example of photographs taken by a doctor, you want to know the circumstances with which you're going to be offering this picture. So if the doctor just finished describing the bruises she observed on the child's abdomen during an examination of a child, the testimony included a date and time of the doctor's exam, right? So some common issues encountered when attempting to admit photos, such as the one that we're going to be using as an example, is showing the photograph to the jury before it's admitted, right? You want to make sure that you lay the proper foundation and that you get the exhibit entered before you show it to the jury if you're publishing to the jury. It's a little different when you are trying a case or handling a hearing in front of a judge. And so we're going to go through the proper, steps to actually physically do that in the next couple of slides. Thinking that the witness must have taken the photograph, or when attempting to admit the photos of injuries, photographs often don't show the person's face. You must obtain testimony from the witness to establish that the photographs are of that specific person and of that person's injuries. And a good example of that is sometimes you'll get a photo taken by a medical professional, and it may be from the neck to the top of the thighs of a young child or an adult, or it might be of an arm, right? So your witness is going to have to answer lead up questions to you trying to lay the foundation for that photo about that person who's in the photo, right? So we can go to the next one. Sorry about that. And forgive me if I'm talking a little fast. Like, this is my first time doing this, so forgive me. So one of the things that you will see in the next few slides is that we list steps 1 through, I think, 10. And those steps are going to be integral throughout this entire presentation. Even though we won't list them every single time we go through a type of evidence that is typically used in our cases, you can refer back to these slides in the future for steps 1 through 10. Okay. So, for example, entering the photos from your doctor witness, right? Step 1 is going to be that you're going to show the exhibit to opposing counsel. Right? You're going to ask permission to approach the witness. You're going to show the exhibit to the witness. Keywords, fair and accurate depiction, right? Now, giving you a little sidebar, a lot of what we do now is virtual, right? So you're going to have to learn your court's rules about how they want you to share information virtually. It is substantially the same, right? You're going to already have shared your, proposed exhibits with opposing counsel. You should be walking through a way to publish that virtually, and you still need to proceed with asking the judge if you can, I guess, lack of a better term, virtually approach the witness, right? So, question, Dr. Jones, I'm showing you petitioner's Exhibit 1. Are you familiar with the scene depicted in Exhibit 1? Is this photograph a fair and accurate depiction of the scene you observed during your examination? Of course, give the witness time to answer in between all of those questions. Step 5, you're going to offer the exhibit into evidence. That's simply done by saying, Your Honor, I'd like to offer petitioner's 1 into evidence. Opposing counsel may object to the admission, so you need to be ready to overcome the objection, whether your prosecutor and defense counsel is objecting to your exhibit being submitted into evidence, or whether your defense counsel. You need to be ready for that objection. Respond to any objection made by opposing counsel. The judge will rule on the objection and either sustain or overrule the objection. If it's sustained, the exhibit will not be admitted. So make an offer of proof, right? That's up to you to do, but we would suggest you make an offer of proof. Step 9, if objection is overruled, the judge will say that the exhibit is admitted. And if you're in a bench trial, hand the exhibit to the judge. In a jury trial, ask permission to publish the exhibit to the jury and hand to the jury after the judge gives permission to do so. One thing I'd like to talk about step 9, between 9 and 10, sometimes we're super excited and, the energy is high when you're doing a trial, right? And if you're not careful, if you miss step 9, you'll move on to your next set of questions. And so will our judges sometimes. And then when you're going back through at the end of your trial, you will often find yourself in a position where you say, well, did I actually offer that exhibit? Did the judge rule on my offer? So you want to make sure that you are paying attention to step 9.
And I'd like to add, Tiffany, if you have the available technology to put the picture up, like if you're in a jury trial, to show that so the entire jury can see it at the same time, that's always a good idea as well.
Mm-hmm. Yes, absolutely. Thanks, Michelle. Okay, so I'm going to go on to the foundation for email or text message. In this day and age, following email or text message, we're going to talk about social media. We do everything through these mediums of communication. I can't talk today. And so the way we authenticate these emails and text messages by the sender's email address or by the sender's email address or by their phone number and by internal characteristics within the context of the message, right? So every email and every text message has a unique identifier. A text message has a number. Sometimes if they're using an app, they have an email address that's associated with it. But there is a specific identifier. Your email has a specific email address. Usually, professional people use their name. People who are non-professional use something that is unique to them, whether it's a nickname, a number, or something. The authentication may also include information external to the content, such as it was found on a person's computer, right? So not that it happens as often in cases that I've been involved in, but if the police have recovered a set of emails as a result of searching someone's computer, then you're going to be dealing with situations where those questions may come up, where you have to lay the foundation that this is how we came into possession of this email or text message, and this is how we know it belongs, or we suspect it belongs, to a certain person, right? The best practice for admitting messages is to break them down into a series of messages and discuss the reasons why the witness thinks that particular message that particular message was sent by the particular person, right? I believe mom sent me this email because she was upset about her canceled visitation. It's like one of the questions that you would elicit. So, Ms. Caseworker, I'm showing you petitioner's exhibit 2. Do you recognize it? She should say yes, right? What is it? Is petitioner's exhibit 2 an exact duplicate of the contents of the email you received on your computer or phone? Do you recognize the email address of the sender, and how? Do you recognize the name at the end of the message? Do the contents of the email refer to any previous communication you had with this person? Is the information in the contents known to this person? Similar to our example of email text messages, social media posts are very similar, right? The foundation is very similar. You want to identify that the person actually has a social media account, right? And one way to identify that when you are questioning a witness is to determine the person's, account name, to determine, whether or not that person has a profile picture on their social media. And the witness may be the actual person who owns the account. The witness may not be the person who owns the account, right? But the witness authenticating the exhibit may testify to the picture or post if they have information about the contents of the post that are known to them. That's a little vague, right? So substantively, what that means is, have you seen it, right? Have you laid eyes on this social media post such that you can identify for the fact finder if what you saw is what is being handed to you in a printed document, right? So entering a Facebook post, and we put Facebook, but really it could apply to Instagram. What's the other one? TikTok. TikTok, not so much because it's video, but if you get still images, TikTok as well, right? So I did something a little different on this one with the commission. I wanted to use mom, right? Even though we don't always get these in through mom, but we use mom. So mom, I'm handing you what's been marked Petitioner's Exhibit 3. Do you recognize it? We hope mom's going to say yes, right? What is it? It's a copy of my Instagram, Facebook, TikTok page. Well, how do you know it's your social media, Facebook, TikTok, Instagram page? Well, it has my profile picture and screen name, and there are photos of me on the printout. Simple, right? But when do we ever get simple? Another example that we didn't list, but that I do want to discuss is, so what happens if you got to get this in through this CPS caseworker? Or what happens if you're defense counsel and you have a Facebook post or Instagram post from one of our CPS caseworkers that would be favorable to your case that we're not offering, right? Then the questions you would ask would be a little similar, but slightly different, right? So I'm going to hand you what's been marked as Petitioner's Exhibit 1. Do you recognize it? What is it? Do you yourself have a social media account? Is that social media account password protected, right? Is it open for anybody else to see? Most folks are going to say, well, I may not have a Facebook account personally, but I have one for work, right? I have one that I use for my investigations at work to manage my cases. Okay, well, does anybody else have access to that? No, right? Then your next question would be, are you friends with mom on social media? She or he may say no, or they may say yes, right? If they say no, then you want to delve a little bit deeper. If they say no, then you want to say, well, how did you gain access to mom's social media? Well, mom's social media profile is public, right? Anybody can see it, right? So how do you know that mom is the person operating this social media account listed, in Petitioner's Exhibit 1, right? That I've shown you pretty much. And you would hope that your witness is going to answer, well, because there's a photo on mom on the profile page and has mom's name, and if, features the child, like all the identifying things that we would be seeking to use to identify the actual document, right? Are there any photos and information posted using this account that only mom would have access to, right? And then going back, one thing that we didn't list in the slide that's posted is the necessity to say before asking to have the exhibit entered is, has it been changed in any way since you last saw it? Did you make any changes to it? That's going to be very important. Okay. That's it on the social media. That's all I got right now.
Okay. So let's talk about audio clips. This might be a situation where a parent or even a caseworker might be leaving messages on a cell phone, on an office phone, something like that, that you may want to get into evidence. And so we're looking at laying the foundation for an audio clip. You want to refer to Rule of Evidence 901. The requirement of authentication or identification as a condition precedent to the admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what it purports to be, or what its proponent claims. So it has to be what we're saying that it is. So here's a couple of some examples of some questions as far as audio clips. Did a respondent mother leave you a voicemail message? On what date and time did she leave that message? Have you listened to the voicemail recording? Was that recording left on a device capable of making an accurate recording? Is that message saved on your phone as a digital recording? Do you have your phone and the original voicemail message with you? Have you provided a digital copy for admission as an exhibit in court? Are you competent to operate the recording device that you used? Is the recording an accurate representation of the voicemail message that respondent mother left you? Has it been altered or edited or changed in any way? Be sure, if it's possible, that you do have that original recording available if it's on a cell phone. Another little tip is make sure you do make a digital copy, because I have seen people try to play it from their own phones during a trial. It's like, well, are you wanting to put the entire phone into evidence? Because you're not going to get it back. So make sure that you do have that as a copy on some kind of digital format that you can actually put that into evidence. And then you want to make sure that you identify the voice on the recording. So you want to have your witness identify the voices that are going to be on the recording. If that's just mom, if there's somebody else on there, they would need to identify that as well. And then is petitioner's exhibit number 4, the tape recording you made of that particular voicemail. And then once you've laid that foundation, make sure that you've identified the voices, that it's on a device that's capable of making a recording. Then you want to go ahead and offer the exhibit and ask to play that message for the judge or for the jury at that time. Okay, Tiffany.
Thank you, Michelle. So similar to photos, audio clips, well, similar to photos and audio clips, laying the foundation for video clips is going to be pretty simple. TRE 901 does apply. Generally, the proponent needs to be able to identify the scene depicted, the voices recorded, and that the video is an original or a copy with no deletions or additions. Most importantly, it must be an accurate depiction of the scene and any conversation recorded. This kind of reminded me of my pre-child welfare years, right? One of the things that we say about videos in the entertainment space is that it's both audio and visual, right? And so when your witness is testifying, your witness is trying to assist you with getting in what they see in the actual video. But if the video has sound, they also have to assist you with getting in what they hear. So questions or steps for laying the foundation for video clips. One of the suggested sequence of questions is, did respondent mother have supervised visits with her child at your office? Were those visits recorded on video? Is it a standard practice to video supervise visits? Are you competent to operate the video recording device that you used? Was the video recording made on a device capable of making an accurate recording? Have you provided the original video or an unaltered copy of the original video for us today? Is the copy you provided a digital copy of the video for admission as an exhibit in court? On what day and time was the video recording made? Practice tip, have the original recording available also for the same reason that Michelle stated in the previous comment, well, in her portion of the presentation related to audio. Can you identify the voices heard and people seen in the video? Is the video recording an accurate depiction of the visit which respondent mother had with her child that you supervised? Is petitioner's exhibit 5 the video recording you made of respondent mother's visit with her child? At this time, offer the exhibit and ask to play the message. I would just like to add in that your witness may not be the person who actually recorded the video. Your witness need only be the person who can identify the persons in the video, who can identify the voices of the persons in the video, and who can identify the depiction of the scenes from the video, right? So if the person who actually made the video is not physically present, your witness needs to be able to testify that they have personal knowledge of the scene that is being depicted in that video footage.
Okay, so we're going to talk about records. And before I get into records, I just want to tell you that, don't feel embarrassed or ashamed if you're in court to take something with you. If you want to take part of this PowerPoint presentation so that you can read what you have to read to make sure that you're laying the foundations correctly. The Children's Commission, they have a toolkit that has some outlines of ways to lay your foundation for certain items. Or if you have some other kind of book for laying your foundation, it's better to read that, make sure that you get that exhibit in, as opposed to floundering around when you get objected to and now you don't know or what to do to go back, or what steps that you missed when you were trying to lay that foundation. So I take my information with me. I take a book with me, a foundation book, so that I can make sure, especially if I know that I have these exhibits that I'm going to need to ask the specific questions for. Okay, so
Michelle,
yeah.
Before you go on, I like to piggyback on that. So they don't let me go to court very much, and when I do, one of the lawyers who I work with, they're usually uber prepared. But because, as some of you may have noticed, I have a stammering problem, right? I stammer, and so I want to make sure that my questions make sense to me. So I go a step further. I will actually prepare my written questions, right, for the particular witness that I'm going to be questioning. And I bug the mess out of the folks in my office to listen to me, to make sure that I'm going through it in the right sequence. And just like you, I'm going to write it down somewhere, and I'm going to write down what the potential objections to my foundation questions are going to be. So I agree with you. If you have somebody that you can bounce your questions off of as well, if you're fortunate enough to work in an office of more than just one person, or if you have a colleague that you can call that has time for you to bounce ideas off of, that's also a good practice to have.
Absolutely. Okay, so let's talk about records. These would be like business records of regularly conducted activity. You want to look at the following rules of evidence: 803, 806, 902. Basically, the purpose of these rules are authentication provisions meant to establish the trustworthiness of the particular record that you're trying to introduce. So as stated before, this exhibit should follow the 3 R's. Of course, you want it to be relevant. Does it prove or disprove something that's at issue? Is it reliable? And then also, is it right? You want to make sure that your probative value is not outweighed by unfair prejudice. So you want to make sure that your probative value is there, that it's not unfair prejudice to the other side, or that it could be misleading to a jury if you're in a jury trial. So in looking at rules of evidence 901, you're going to look at identification, a condition that's precedent to admissibility, and that it's satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims it to be. So just like we talked about before. So records of regularly conducted business, that we call these business records. So what kind of records are covered? This could be a memorandum, it could be some kind of data compilation, reports, records, just anything that's in any form that has the acts, events, conditions, opinions, or diagnosis. So a lot of times I might use these as hospital records. Say that there was a baby born with drugs in their system. I might use hospital records, or you have a severe medically needy child, abuse. And so you might want to get these records. I've also used this for service providers. If, a psychological therapy records, I also use them for police reports. And so there's a couple of different ways that you can get in these types of business records. So the first way that we could do it is through a custodian of records for that business. Another way is through an affidavit, which is the way I prefer, is to go ahead and get an affidavit. And so then you can get those on file, or get them out to the, not on file anymore, but get them out to the other parties. You can also have another qualified witness. This is a person who is credible and can credibly testify to those records that satisfy the requirements to get these records in. So they would really have to have information regarding what the business records are in order to get those in. Okay, so this is an example. If you didn't have time to get your business record affidavit and you have to call your witness to testify, this is an example of what you might do. So of course, like Tiffany stated with the photos, You're going to request permission to approach, pre-mark the exhibit. If not, have the court reporter do that, and then show it to opposing counsel. Sometimes I don't show to opposing counsel till afterwards, but a lot of my courts require us to exchange exhibits anyway, even if we're in person. And so you've probably already given them a copy. So here's what you're going to be asking is, I'm showing you what's been marked as petitioner's exhibit number 6. Do you recognize it? What is it? How do you know what it is? Are you the custodian of records of the hospital? Are you familiar with the manner in which its records are created and maintained? Are these original records or exact duplicates? More likely than not, they're going to be exact duplicates. It's very rare that you're going to have original records because the place that you're getting them from wants to keep them. I've very rarely had anybody want to give me their original records. Is it the regular practice of the business activity to make this record? So is this routine? Do you always make records? Usually in hospitals, the doctor is making a record, or at least saying, and somebody else is making that record. There's things that are written down, or it's put in a computer. Same thing with police officers. They write reports. It's their routine to make these reports and to keep these records. Were the records made at or near the time of the event or the condition? And is it the regular practice of your place, the hospital, whatever it is, to make this type of record at or near the time of the event? And were the records made by or from information transmitted by persons with knowledge? So 1, were the records made at or near the time of the event? 2, were they made by or from somebody with knowledge of that event? Because a lot of times you have somebody's transcribing what the doctor's doing, or something along those lines. So you want to make sure that this is the foundation that you're laying as far as laying your foundation for business records. Or is it the regular practice of this business for this type of record to be made by or from information transmitted by persons with knowledge of the matter? Did the person with knowledge act in the regular course of business or have a business duty to report? Once you've laid that foundation, then you want to go ahead and offer into evidence petitioner's exhibit number 6. And so you would move to admit or offer to admit to the court. So the other way, and this is the way I really prefer to do it, is by affidavit. So of course you have to get the affidavit, send it to the custodian of record, who will fill it out, and they put the page number, and then the records are attached. And you have to give this to the other parties 14 days in advance. And so you want to look at Rules of Evidence 803, 6, and 7, because this is going to tell you what is required in order to get the exhibit introduced as by the affidavit for this business record.
And it's also going to tell you that you don't have to file the actual business record with the court, right?
And so that's exactly right. Used to, back in the day before 2014, you had to file these big records with the clerk, and so then the other party could come in and review the record. So the legislature in 2014 changed it. So now you have to serve on the other parties at least 14 days. So 2 weeks before your trial, you have to serve those records on them. And then I do file something with the court that says, I served hospital records on respondent mother to all parties, via e-serve or however I did it. And I file that with the court so that the court is aware that I did file it, but I actually send the records to the parties because that's what the new law is, back at least since 2014. And you want to make sure that affidavit conforms to the substance of your model affidavit there in Texas Rules of Evidence 90210B. So what are some of the challenges if you want to object, or you might get these objections? And so like Tiffany was talking about, be prepared for some of these objections. It could be hearsay, authenticity, relevance, personal knowledge, prejudice, or original, but I don't really see that very much because most of these records are copies of the original. So you might think about the challenges that you might get and be prepared to answer that, and make sure that you're going through laying that foundation specifically so that you don't draw this the objections. And if you do, then you're ready for them because you're ready for the you know what the objection may be. But if you want to make an objection, then these are the objections that you may want to make. Sorry about that. Tiffany.
Okay, so foundation for hearsay statement of child abuse victim. I gave a presentation with our general counsel team a couple of weeks back on legislative changes, and it was unique to hear the criminal DA, because in our county we have the DA's office and then we have the county attorney's office who handles the civil matters. But it was unique to hear how our criminal prosecutors prepare for outcry statements or hearsay statements of child abuse victims. Their age limit is different, and it's a whole different kind of set of rules, right? So as it relates to Texas Family Code 104.006, in a suit affecting the parent-child relationship, a statement made by a child 12 years of age or younger that describes alleged abuse against the child without regard to whether the statement is otherwise inadmissible as hearsay is admissible if, and here's the part that a lot of people miss, in a hearing conducted outside the presence of the jury, the court finds that the time, content, and circumstances of the statement provide sufficient indications of the statement's reliability, and the child testifies or is available to testify at the proceeding in court or in any other manner provided for by law, or the court determines that the use of the statement in lieu of the child's testimony is necessary to protect the welfare of the child. So staying on this slide for a little bit, a couple of things that stand out, right? A lot of people, prosecutors and defense counsel alike, believe that just because a child makes a outcry, that's coming in, right? That statement's coming in, whether it comes in through a therapist, whether it comes in through your forensic interviewer, that it's coming in. However, we need to pay close attention to this section of our family code, right? Whether you do it in pretrial, whether you do it at a permanency hearing, whether you do it at a show cause or a adversary, as y'all call it in some counties, right? You want to make sure that the court is going through this analysis such that on the record, the judge makes these findings, right? That either this child testifies or is available to testify at the proceeding in court. The child necessarily doesn't have to testify, but the child does have to, there has to be the availability of the child to testify, right, at the proceeding in court or by deposition, right? There are some unique things that I know that a lot of you who are watching us now have heard of Versal Rush. She did an awesome presentation on how to secure a young child's testimony and specific to an outcry of abuse and or neglect. So in any other manner provided for by law, right? Or the court determines that the use of the statement in lieu of the child's testimony is necessary to protect the welfare of the child, right? That analysis has to be done. You're going to be asking, or even putting forth evidence during this actual hearing, wherein you're testing the reliability of the child's statement. You're testing, whether or not it's going to do more damage to this child to make a physical appearance in court, to confront their abuser in open court. And so whether or not the use of the hearsay statement through another person who the child made the hearsay statement to, right? Whether that's a forensic interviewer or a therapist is actually necessary to protect that child, right? On our next slide, I think we talk about what matters is the child's age at which the statement was made, and not the child's age at trial, right? It may take us a year or two to get down the road. If a child was 12 at the time the child made the outcry, but now the child is 13 or 14 at the time of trial, the analysis is still the same. It is at the time the outcry was made and not the age of the child at the time that the hearing or trial needs to go forward. So in Ray SP, the court found that a trial judge's common sense that making an 8-year-old confront in open court the man who abused her is insufficient to support the finding that the statement in lieu of the child's testimony is necessary to protect her welfare. That basically means that the analysis has to be done, right? The fact that we think common sense should take precedence over actually making the findings on the record, I think that this case was indicative that common sense ain't common, right? That it's got to be laid out. I tell people that all the time. Common sense ain't common for some folks, right? So you want to make sure that your judges in all of our jurisdictions are going through this analysis and making the necessary findings. Something also I want to touch on that I did not, about the reliability. When we talk about the reliability of a child's outcry, a child's hearsay statement, right? We talk about, whether or not the child knows things that the child just shouldn't know, right? That when they make the statement about their abuse, especially if it's sexual abuse, right? If it's sexual abuse and there's a 5-year-old and the 5-year-old can tell you details about the human anatomy that the 5-year-old shouldn't know about at that age, then you're helping the fact finder get to the point where they're making determinations about a child's inability to lie or motivation to lie, or you'll be eliciting information from your witnesses about the other corroborating evidence that may assist with verifying the child's story, right? Couple more things. We didn't give you particulars on questions that you would ask if the court determined that a child did not need to be present and that the child's hearsay statement could be used, which means that you need to get it in through a person who is not the child. And so one of the ways that you could do that is by, after the judge making that determination, going through like a quick, well, it won't be quick like in real life, but on here it's going to be quick, right? So are you 18 years of age or older? How do you know the child, right? The person will say, I'm the therapist, I'm the forensic interviewer, I'm, one of those things, or I'm the medical doctor. I don't know, I'm the caseworker, right? How old is the child currently? Did the child make any statements to you about being abused? When were the statements made? Where were the statements made? To your knowledge, were you the only person the child were you the only person the child told about the alleged acts of abuse? In detail, what did the child tell you regarding the abused? What did the child tell you about the abuse that was alleged? And is the child available to testify during this trial? Right. So you want to just keep hitting those points again. That is what I would do anyway when they let me get in the sandbox and play. So.
And Tiffany, the way I've shown up that to protect the child's welfare is often I've called the therapist for the child to say, what's going on with the child? How would the child not being there, how would it protect her welfare, or what kind of damage could it do to him or her? And so I've been able in certain situations with some sexual abuse where I've been able to not have the child present because of the to protect their welfare due to the testimony of the therapist at that time.
That's a really great point. Something else that I don't see a lot of practitioners using, her head's probably going to explode me saying the versal rush method, right? But she demonstrated for us, and when I was working in Liberty County at one time, how to take the deposition of a child with all the lawyers being present, with no objections being made at that time, right? And then bringing that recorded session back to the court, and then making our objections in real time with the same court reporter or stenographer. That worked out really well in a trial where we had some severe sexual abuse and some severe emotional abuse, by a mom and stepdad, as it related to two very strong little girls. And even though one of the little girls, she was about 9 years old, she wanted to testify. She wanted to see her mom. She wanted to tell her story. But I love the fact that even though I feel how I feel about a lot of things, that this provision of the family code, I think, exists to help us refocus that the nucleus of all of our cases should be the protection of children. And if we can avoid having them retell their story over and over and be re-traumatized over and over in front of a bunch of people who are strangers to them, essentially, that if we can do our best jobs to have them tell their story just one time, I think that we've overcome a huge hurdle by making sure that they don't have to repeat all the bad things that have happened to them.
And that chapter 104 has some other sections. The one that you were just talking about, Tiffany, is 104.003 about pre-recording the videotape. There's also 104.002. This is what I've used in the past for like a CAC video. It's a pre-recorded statement, child's 12 years age or younger. And then also there's 104.004 where you can also have the child in another room and it's broadcast. But I just encourage you all to look at that chapter 104. There are some different ways, like Tiffany's talking about, that we can protect these children from having to testify or having to confront the person that has abused them. There are ways that we can do that under that chapter 104. And so look at that chapter if you have that situation that's coming up. I think that there's different things in there that can help you. Some of them are age specific and some of them are not. Okay, so let's talk about drug test results. Typically, you will have 3 experts to get your drug test result admitted into evidence. You're going to have a chain of custody witness. So this is the person that took the sample at the drug testing place. So the person that cut the hair, the person that, I guess, watched the parent pee in a cup, whoever that is, that's your chain of custody witness. Then you're going to have an expert that establishes the theory's validity and the proper technique to implement that theory, and then an expert that testifies to the test results. Now, sometimes those 2 people can be the same person. And if you have that person, it's usually a supervisor, director of a lab, and they can testify to both of that second and third prong that I just talked about regarding the reliability and then the test results themselves. And then they can testify from a business record. So if you're getting your test results in this way, you want to get what's called a litigation packet from that has the test, and it's a big old packet, and it starts out with the information from the person who took the sample all the way through, the labs, what tests were done, that everything was done correctly, to the results and that kind of thing. Just remember that the person who actually took the sample or administered the test, that's not enough to actually prove up a test result. You have to have that expert. And I'll say that's one of the good things, if there is a good thing about COVID. And now we can get those people to testify on Zoom. Before, we'd have to bring them in, and the experts were very expensive to bring in to testify. So drug tests may not be admissible if the source of information or the method of preparation indicates a lack of trustworthiness. There can be error if the person conducting the test is not qualified, and if this is not a standard or accepted test for this particular substance. So that may be when error could be found. So I have a couple cases out here that I wanted to talk to you about. KCP, this is a little bit older case from 2004 out of Texarkana, but it talks about that drug test results are not necessarily reversible if there's other evidence that the parents used drugs. So if respondent mother was on the stand and admitted that she used methamphetamine, then it's going to say that if you follow KCP, then entering in those results is not going to be reversible error because the mom already admitted to that. The other thing that KCP talks about is that because termination is a little bit higher burden of proof, it's clear and convincing, that that may be where you really want to lay that foundation, the proper foundation with your expert. It appears that it might not be the same for adversary hearings, or at least that's what the court in KCP says, because the burden of proof in an adversary hearing is obviously much lower. Now, AT is as to hospital records. So this was where hospital records were introduced into evidence. They had a business record affidavit, and within the hospital records, there were drug screen results. And the court in AT said that because that affidavit laid out the who, when, what, where, that it was admissible to show the drug screen results because everything was laid out in the affidavit and within the records. And so it was admissible. I will say, though, that there was a record within that business records from another lab. And the court did say that that wouldn't come in because it wasn't a record of the hospital. It was one that the hospital incorporated into their records. So just be careful if you have other records within your hospital records that the hospital retrieved from somewhere else and just incorporated it. Some other cases that don't necessarily are following KCP. We have one out of Eastland. This is EB. And basically they upheld, this Court of Appeals upheld the admission of a drug screen with a proper affidavit by the custodian of record because it set out the chain of custody, the testing procedures, qualifications, or the analysis of that. And so it said that it met and satisfied Texas Rules of Evidence 8036 and 90210. This court did not read KCP to require live testimony. There are also a few courts out of the Houston area, the 14th Court of Appeals, and out of Fort Worth, that have also held that there's no requirement for expert testimony in order to get in the drug screen results in a termination case. And this case is fairly new out of Beaumont. This is from this year. This one, basically what happened is that the test results were entered in. It had a business record affidavit. And the Court of Appeals there in Beaumont was saying because the lab results said that it was DHH certified, so that's the Department of Health and Human Services, that it included reports signed by a certified medical review officer. So this is a physician with the training for collection procedures and training regarding interpreting these results. And that once the department established that these records were authentic, then the burden of proof shifted to the parent to prove the source of information, method of records were prepared, or that the circumstances behind them lacked an indication of trustworthiness. So what they were saying is that long as the business records are appropriate, authentic, and can they're certified by somebody with a lab with the Department of Health and Human Services, as well as a medical review officer, they're saying that that comes in unless the person that you're putting the test result in on can refute that particular trustworthiness. So this is a fairly new case that allows that to come in. You can get TDAT, Texas Drug and Alcohol, something like that. Tiffany, remember what it's called? They will give you a business record affidavit for those drug screens that you can get in, and they all should be this Department of Health and Human Services, and they're always reviewed by a certified medical review officer. So briefly, some of the objections that you can make: chain of custody, hearsay, lack of proper foundation, maybe the prejudice outweighs the probative value. And then just briefly, I want you to be aware of thresholds. So threshold is their minimum levels of detection values that are established to minimize the potential for testing positives due to incidental exposures. We, the department, we go by the SAMHSA values. Most government agencies do that. And so what I want to say, though, is that there are other testing facilities or agencies or employers that do not follow these particular values or that are established, these particular thresholds. So if a parent, or if you represent a parent and you want them to go get their own drug screen, make sure that the threshold that they're testing their drug screen is the same as the department's, because that's what's going to be looked at. If they're getting drug screened through their work, the same thing, because they can choose a different threshold level when they test their urine or hair or whatever that is. Okay, I know, Tiffany, you kind of touched on this just a little bit about remote hearings and making sure you know your court to when you're ready for your exhibits and things like that. Is there anything else that you wanted to add?
Courteousness is not dead. I know that this is not a civility training, but courteousness is not dead. And even when we are, fighting, and we are fighting for our own positions to protect children or to send children back home, whatever they are, civility is not dead. And part of our civility towards one another is also exchanging exhibits in a civil way, right? My team doesn't hide the ball. That's not something that we do. I don't think that I've ever worked across the table from attorneys who hide the ball, but boy, it sure can get nasty. So I am sure judges don't want to see us be nasty with each other in court. So if we can at all, be more cognizant and mindful of civility towards one another, I think that we could get some good outcomes for children in all of our counties. So that's something we didn't put up there, but again, I've said it like 5 times now, civility is not dead.
Renee, I think we left you about 3 minutes. Is there a couple of questions that we can answer?
There are a couple of questions that did come through. And so in our time that we have left, I'm going to try and see if we can get 1 or 2 of those answered. First question is, when trying to admit text messages, social media posts, or emails from a parent through someone other than the parent, like your caseworker, one of the foundational questions listed was, why do you think the parent sent this post? Or why did they send this? Or why did they post this message to Facebook? Wouldn't this draw an objection for speculation?
I would say in that context, yes, it would. But if prior to your questions leading up to laying the foundation are, did you have an opportunity to speak to mom? Okay, I'll give you a better example. Did you have an example like mom's not supposed to be dating dad, right? Mom is supposed to be staying away from dad. It's domestic violence or whatever. Mom, testifies right before you put your caseworker up. Oh, I haven't seen dad in 10 days. I've not had any contact with dad, right? Well, then in your head, oh, I got a social media post that shows mom and dad on a date just last night. My caseworker sent it to me last night. So I'm going to ask some questions leading into me wanting to offer this as an exhibit. So you can capture all of that before you actually have to go through your foundational questions. So to your point, you're correct. I believe you would be asking those questions as a preamble to laying the foundation, right? It would be, based upon, what has mom had any contact with dad? Yes. Well, how do you know that? I saw it on a social media page. Oh, you did? Yes, I did. Well, Judge, I'm going to publish to opposing counsel. I'm going to start laying my foundation on that. So yeah, I'm glad that person asked that question. So hopefully that clarifies it a little bit. I got too excited about that one.
Do you have a few more questions? It looks like we're near time. So I'll ask one more, and then I will submit the rest of the questions to our speakers and then provide those responses to everyone via email. But of course, you can still withdraw an objection even after you lay the proper foundation. So how can you best anticipate and prepare for those hearsay objections?
Since I answered the first one, I'll give Michelle an opportunity.
I would just be like, let's say that the hearsay is something within a business record, such as a police record, and it's got a statements from a third person, from a bystander or something like that. Be prepared for something like that. And so you could bring a copy of that record with you with those kinds of things delineated out already. And a lot of times, you know, the hearsay that's in there doesn't go to the truth of the matter asserted. So make sure that you know what your, you know, how you can get things in, what might be your answers to hearsay. How do things still come in? Party opponent, whatever that might be, and so that you can be prepared. Sometimes people will just object to throw you off of your game. And it might just be, you know, Judge, I laid the proper foundation. And if they want to be more specific, then they need to get specific. So I think just know your answers, that you've covered your bases on how to lay that foundation, and you'll be good to go.
And also following the rule of watching the Ken Paxton hearings, right? You want to make sure that people are actually making legal objections and not talking objections. So don't be afraid to say, Judge, what's the legal objection? Because often folks ain't making legal objections. They're making talking objections. Don't be afraid to say that.
Great. Thank you all so much. That is our time for today. On behalf of the Children's Commission, I would like to thank our panelists, Michele Surratt and Tiffany Reedy, for providing that excellent presentation. A recording of this webcast will be made available on the Commission website, and individuals who watch the replay may contact cctraining@txcourts.gov for the MCLE self-report information. The State Bar has approved this course for 1 hour of MCLE credit. Thank you once again for joining us, and I hope you have a wonderful rest of your day.